would not be pleased to have Thom Lambert here speaking to us on antitrust issues, but in fact I am. I've been reading up on you, sir, and you have a very impressive record, even though it includes a good deal of service in the state of Missouri. But what I can also say is that he's gotten just about every major award that the University of Missouri can award, and that speaks volumes. Mr. Thom Lambert, law professor at the University of Missouri.
Well, thank you so much for the chance to be here and to talk. I really do, as much as I make fun of Kansas, I love to come to Lawrence. First time I visited Lawrence, I got this sort of sick feeling as soon as I got out of the car, because it is really a nice town. And I didn't want that to be true, but it is, and Katie's a great place, so thank you so much for your hospitality. So I've been teaching antitrust at the University of Missouri now for a lot of years. I haven't taught it for the last few, but I'm back in there this semester. And when I first started teaching, I'd tell people that I taught antitrust, and often they would say, do we still have an antitrust law? And nobody asks that question anymore. Antitrust is back, big time. It's having its moment. So we've heard a little bit about this. The Department of Justice and the Federal Trade Commission have been looking at Google, Apple, Facebook, Amazon. We've got 47 or 48 attorneys general investigating Google, led by a Republican, Facebook, led by a Democrat. There's a sort of bipartisan consensus that we should go after these companies, or at least investigate them. And it's not just tech related. So there's a lot of emphasis now on declining wages and maybe monopsony power in labor markets. Concentration among employers is leading to declining wages. There's a lot of emphasis on the rise of index funds and some concern that the fact that most major corporations have the same top shareholders is leading them to compete less vigorously. Robert Bork appears in the Democratic debates, and he's called out by name in the presidential debates. I mean, this is a very exciting time for antitrust professors. So what I want to do today is to step back and ask a couple of sort of foundational questions. One is, what are antitrust limits in addressing all these things that's now being called on to address? And two, how should courts and antitrust enforcers act in light of those limits? Now, I want to use as a springboard one of the most famous antitrust articles ever written. It was written 35 years ago by then Professor Frank Easterbrook, now Judge Easterbrook on the 7th Circuit, called The Limits of Antitrust, and he asks exactly those questions. Now, he's writing in the mid-80s. His article, The Limits of Antitrust, has been cited more than 700 times in law journals. That's a lot for an antitrust article. So what I want to do today is, there we go. Three things. Review the basic argument of The Limits of Antitrust, the 1984 article by Easterbrook. I want to assess its prescriptions in light of the current situation. Does it stand the test of time? And then I want to suggest some sort of friendly amendments to his article. All right, so let's jump right in. I think that this article by The Limits of Antitrust can really be broken down into three main points, which I call the Voltaire point, the incommensurate harms point, and the screening mechanisms point. So to get your head around the first of these points, the Voltaire point, you have to think a little bit about what is antitrust domain. What I mean there is, what type of behavior is antitrust designed to deal with? Well, it deals with business behaviors that generate market power. So that can happen in collusion when nominal competitors agree not to compete with each other. It can happen when you have a dominant firm that engages in exclusionary conduct. The two primary provisions in the antitrust law, Section 1 of the Sherman Act, Section 2 of the Sherman Act, correspond to those two things, collusion and exclusionary conduct. But when we're talking about these types of business behaviors that might create market power, most of them are what I would call mixed bags. So if you charge really low prices, there's something good about that. Consumers like having really low prices, but you can exclude your rivals from the market and get some sort of a competitive advantage. If you engage in an exclusive dealing agreement, so you enter into an agreement with a distributor, you can trade in only my brand of a product. There's a lot of distributional efficiencies that can arise from that sort of an agreement, leading to lower prices, more output, but it can exclude rivals from the market. Resale price maintenance, which we talked about when a manufacturer sets the minimum resale price for its product, that can lead to collusion among retailers, shore up a collusive scheme, or shore up a manufacturer-level collusive scheme. But it can also lead to greater distributional efficiencies, etc. So anytime we're talking about anything that antitrust regulates, it can have some good effects and it can have some bad effects. It's a mixed bag behavior. Now, there are inevitable costs anytime you're, I'm going to move back here because I like to look at my slides. There are inevitable costs anytime you are trying to regulate a mixed bag. And the first cost is this. You can make a mistake. That's the image you get if you Google, I made a mistake. Now you can make two types of mistakes. One thing that you can do is you can falsely condemn, wrongly condemn good behavior. You can have too broad a prohibition. So a false conviction, economists would call that a type 1 error. The other thing you can do is that you can wrongly allow bad behavior, a false acquittal, call that a type 2 error. Now, social losses occur anytime you have one of these mistakes. You're condemning something good, you're failing to condemn something bad. Collectively, we would call those the error costs of your decision, your rule, whatever. A second set of costs are just the cost of deciding whether something is allowed or prohibited. And that's a cost, of course, that's borne by the business planners when they're trying to decide what they can and can't do. It's borne by enforcers when they're trying to decide whether to go after conduct or not. It's borne by judges, etc., when they're trying to decide if something is allowed or is not. So these are inevitable costs anytime we're trying to regulate mixed bags like antitrust regulates. Now, this leads to dilemma here. These three costs, false conviction error costs, false acquittal error costs, decision costs, are inextricably intertwined. You can't drive down one set of costs without driving up another set of costs. So if you decide, I don't want any false convictions, I don't want to forbid anything that's bad, then you have a generally lenient rule and you let, I don't want to condemn anything's good, you let bad behavior exist. If you try to forbid all the bad behavior, then you accidentally condemn some good behavior. The response then would be, okay, let's have a really nuanced rule that has a lot of general prohibition, but 16 exceptions so that we don't condemn anything bad. Well, that of course drives up your decision costs. So it's like playing whack-a-mole. If you hit down the costs in one area, they just pop up in another. Anybody recognize this fellow? This is Paul Volcker. You may have heard of the Volcker Rule, the former chairman of the Federal Reserve Board. The Volcker Rule was a financial rule that said federally insured banks will not be allowed to engage in proprietary trading to boost their own profits. This is a financial rule that the Wall Street Journal liked. Right? So it doesn't like a lot of financial rules. So it had a very, very broad support. Now, when it came time to write the rule, it was really hard to do because you don't want to forbid banks from engaging in legitimate hedging transactions. That's something that they need to do in order to protect their depositors. So, we want to condemn the bad stuff, risky, speculative, proprietary trading, allow the good stuff, legitimate hedging transactions. In order to do that, we had to have a pretty nuanced rule. So when this rule was actually written, it ended up being 1,077 pages long. That is not to disparage the Volcker Rule, it's just to show how inextricably intertwined these three concerns are. You want to forbid the bad, allow the good, and keep the rule simple. It's really, really hard to do that. All right, so what should you do in a situation like that? We've all been in this situation before, right? This happens to me every time I go to my parents' house. The blanket doesn't fit, right? It's too small for my body. So I can't get my chest warm and my feet warm. It's just not going to cover me fully. That's a terrible situation to be in. But I have learned, when I go to my parents' house, that there's typically a way I can turn that blanket around to cover the most of me possible. Right? I can optimize this blanket. I can't achieve perfection with the blanket. I'm not going to cover everything I want. But there's a way I can do it where I get the most possible benefit out of the blanket. Right? This was Easterbrook's point, first point, what I call the Voltaire point. I'll tell you why in just a second. He says, don't try to forbid all the bad. Don't try to allow all the good. Don't try to maximize simplicity with the law. Instead, what you want to do is minimize the sum of error and decision costs. That's how antitrust should be structured. That's what enforcers should do. Right? Now, I call that the Voltaire rule because it's consistent with Voltaire's prudent maxim, the perfect is the enemy of the good. Don't pursue perfection on any of these fronts. Instead, try to get the most you can, minimizing the sum of decision and error costs. Right, so that's the first point that Easterbrook made. Now, the second point, which I call the incommensurate harms point, these are two very dangerous creatures. I can tell you that I have one of these that lives in my home, and he is dangerous, and the only reason I can have him in my home is he's too small to kill me. Both dangerous. One is significantly more dangerous than the other. Right? Easterbrook says this is true also about these two types of error, false acquittals and false convictions. The thing about a false acquittal in the antitrust context is that if you wrongly allow a bad practice, you're going to get market power, which results in higher prices, which invites entry into the market. It's not durable, it's self-correcting. On the other hand, if you have a false conviction, if the court wrongly forbids something that's actually good, that error remains until you get another court that comes along and overrules the old precedent, which it can be a very long time coming. We talked about Legion. Legion was a 2007 Supreme Court decision that overruled a really bad decision from 1911. 1911, there was a bad precedent that persisted for 96 years. So Easterbrook says, look, if you're going to err in one direction, you should err in the direction of false acquittals rather than false convictions. So this would call for a relatively lenient antitrust law. All right, Easterbrook's third point is what I call the screening mechanisms point. He said, if we want to implement a system like that, we got to find a way to do so in an administratively easy way. So one way to do that would be to posit these sort of screening mechanisms for particular antitrust challenges. So he set forth 5. He said, does the defendant have market power? If the defendant doesn't have market power, there's probably not going to be any kind of anti-competitive harm from its actions. Would the challenge practice enhance the defendant's profits by reducing competition? If not, then it's sort of self-deterring behavior. Is the vertical practice widely adopted throughout the industry? So what I mean here by vertical practice is an agreement between typically a manufacturer and a distributor. What he said was, most of these vertical practices, in order to have an anti-competitive effect, have to be widely adopted in an industry. If just one manufacturer enters into these agreements with its distributors, it's not going to have much of an effect. So we shouldn't worry about this unless the practices are widely adopted throughout the industry. Fourth one, he says, courts should ask, is the defendant's output and market share falling? So market power arises or is exercised when producers reduce their output so as to cause prices to rise and thereby enhance their profits. So if the defendant is not experiencing a reduction in output and a reduction in market power, market share, it's probably not engaged in any competitive conduct. And then finally, he says you should ask if the plaintiff is a customer or a competitor. So customers benefit from increased competition. Competitors are hurt by it. Competitors benefit from reduced competition. Customers are hurt by reduced competition. So ask who it is that's complaining. If it's a competitor complaining, they're probably complaining about an enhancement in competition. Whatever it is the defendant is doing is making them more efficient and a better competitor. If it's a customer that's complaining, then there probably is some sort of anti-competitive activity occurring. All right, so that's Easterbrook's basic argument, and was incredibly influential. Now I want to very quickly just sort of assess it. What do we think of these things? Well, with respect to the first point, the Voltaire point, I think that that is unquestionably, it stands the test of time. Antitrust still deals with mixed bag misconduct, or mixed bag conduct. You can still have these errors. There are social losses anytime there's an error. The interaction between false convictions, false acquittals, and decision costs, they're still inextricably intertwined, and the wise thing to do here is to try to optimize. So that point passes the test of time. The incommensurate harms point, I would say proceed with caution on that. We have seen that some forms of market power, are sort of self-correcting. So when market power arises from collusion, agreements among competitors, etc., that tends to be pretty fragile market power. Every competitor has an incentive to cheat, and it tends to self-correct. But we've seen now that sometimes market power can be durable, especially in industries where you've got big economies of scale, network effects where a provider's product is more desirable, the more people use it, etc. It can be difficult to enter into the market and underprice a monopolist. So I would say that the harms aren't always incommensurate. You have to sort of look and see what is the nature of the anti-competitive effect to decide whether it's going to be durable or fleeting. With respect to the screening mechanisms, I won't spend time going through all of these. The first two seem to have passed the test of time. They are incorporated pretty much into antitrust law. No one thinks that this is particularly controversial. But I would say that the third and fourth of these screening mechanisms, we've learned some stuff since Easterbrook wrote this article that calls these into question. So we now know that sometimes a vertical restraint that's imposed by just one producer, if it's a dominant producer, can have an anti-competitive effect. If it forecloses the producer's rivals from the market, it can cause them to lose scale, become less efficient, you can raise your rival's costs. So there can be anti-competitive harm even if the vertical practice isn't widely adopted by industry participants. In addition, number 4 is the defendant's output and market share falling. Well, if a defendant is engaged in exclusionary conduct, excluding its rivals from the market, its market share is going to tend to rise. Rivals are being excluded from the market. And its output might also rise if the market as a whole is rising. So this is proven not to be such a great screening mechanism. The fifth one is the plaintiff a customer or competitor. Again, I give a yellow because I think this is helpful, but it probably needs a little tweaking. So we now know that there are some anti-competitive harms, particularly arising from exclusionary conduct, that harm the competitors because they're getting excluded, but they also harm consumers because the exclusion of the competitors shores up monopoly power, etc., leads to higher prices. So they can both be injured. So you can have a competitor complaining about something that is legitimately anti-competitive. I think where this screening mechanism still makes some sense is if you see competitor complaints without consumer complaints, then that looks pretty fishy, right? So there's something to this, but I think you need to tweak it a little bit. All right, so that's where I would say we are with Easterbrook's original article in light of where we are today in our economy, etc. What I want to do with the rest of my time is to sort of go through some additional screening mechanisms that I think would be appropriate for today, where we are. Right, so the first one is this. Does the challenged practice entail consumer harm? Now, Easterbrook, somewhat surprisingly, didn't mention this as in a screen when he wrote his article. And it's not because Easterbrook didn't think that antitrust exists to protect consumers. He's a professor at the University of Chicago Law School, a card-carrying member of the Chicago School. He probably didn't mention this because he didn't think he needed to. He was writing in 1984, 1985, I forgot 1984, I believe. And it was pretty well established at that point in time that the focus of antitrust is consumer welfare. In 1979, the U.S. Supreme Court, in a case called Ryder versus Songtone, said that specifically. The Sherman Act is a consumer welfare prescription. So this was pretty well established at this point. I don't think Easterbrook felt like he needed to posit this as a screen for antitrust actions. And the times have changed. As you probably have picked up on from today, if you've been here very long, there's a lot of pressure now to change this consumer welfare standard, the standard where we say no antitrust liability absent consumer harm. And challengers have said, look, there's a lot of problems with this consumer welfare standard. It can't address a bunch of things. So it has a hard time addressing buyer market power. When buyers have market power, buyers of input, or employers who are buyers of labor, they have the ability to drive down the prices that they're paying. So they pay lower input prices, they pay lower wages to their laborers, etc. And that can manifest itself in lower output prices. So if you're just focused on sort of low output prices, consumer welfare, you're not going to catch buyer market power. Another challenge, innovation harms from giant efficient firms. So, if we're just focused on prices, we're going to want to have like these giant efficient firms with huge economies of scale and that sort of thing. They have very low prices. But there is some concern when you've got these behemoths out there that we're going to see reduced innovation. A couple of reasons for that. Some people have argued that small businesses are more innovative than big businesses, and if they can't sort of stay in the market, we're going to lose the benefits of their innovation. Others have talked about this kill zone, which has been mentioned a couple times today, that if you're innovating in the area near a big company like Facebook or Google, your ideas are either going to get appropriated by them or you're going to get bought out on the cheap. And so we're going to see a decrease in innovation if we focus just on consumer welfare. Third limitation, what about harms in zero price markets? People don't pay for Facebook. People don't pay for Google. So it's hard to point to any consumer harm, but there may be harms that exist because of lack of competition in the form of reduced privacy protections, etc. Some people like Lena Khan, who's been mentioned a number of times today, say that the consumer welfare standard, because it is focused on short-term price effects typically, doesn't actually protect long-term consumer welfare. So if you let a company like Amazon run amok because right now it offers low prices that consumers love, etc., we may end up actually with competitive structures that in the long run don't inure to consumers' benefits. And then a lot of folks are pointing to other harms that stem from bigness itself. You've heard the term today, I believe, the neo-Brandeisians, that term has been used. That comes from Justice Brandeis' book that he wrote called The Curse of Bigness, where he says, big business is sort of bad in itself, per se. So here are some harms that stem from bigness itself. You get the loss of small businesses. There's something desirable about having an economy with a whole bunch of small businesses in it. Wealth inequality, when we have these giant Silicon Valley firms where the principals are making gazillions of dollars, we have an extreme amount of inequality. You can kind of see that if you go to, Palo Alto, Silicon Valley. You can't live in Silicon Valley if you're just a normal person. I mean, you have to be rich to live there. Harms to democracy as bigger businesses have more sway over the government. So all of these things are harms that stem from bigness, but they don't manifest themselves as consumer harms. So the neo-Brandeisians say we should get rid of the consumer welfare standard. All right. I would say let's not do that. Let's keep the consumer welfare standard. A couple of reasons. First of all, a number of these harms are addressed by the consumer welfare standard. So long-term consumer welfare, the thing that Lena Khan is concerned about, is obviously addressed. Maybe we are focusing too much on short-term price effects, but the consumer welfare standard ought to look in the long, to long-run effects on consumer welfare. If it's properly applied, it should do that. Buyer market power is also addressed by the consumer welfare standard. A couple points here. when we talk about consumer welfare, that really should be phrased, the welfare of the person on the other side of the market. We don't, so that, we should think about it that way. If buyers are monopsonizing a market, they are hurting the person on the other side of the market. That's really what that means. So antitrust is well established that antitrust reaches monopsony power. In addition, even if you're focused on just end user consumers, well, consumers are hurt by reduced quality. If we have monopsony power in buyer markets, that's going to mean that we're driving high quality inputs, high quality employees out of the market. We're not optimally allocating those labor resources, inputs, et cetera. And at the end of the day, the consumer products that are produced are going to be less good. Right? So the consumer welfare standard captures buyer market power. Innovation harms. The horizontal merger guidelines specifically mention this as something that should be considered. From 2004 to 2014, the FTC challenged 164 mergers. They alleged harm to innovation in 54 of those things. So the consumer welfare standard is looking out at innovation harms. Some of these other harms are, I believe, better suited to other legal fixes. So privacy is probably better dealt with privacy regulation, preferably national regulation, so we don't have patchwork among the states. Inequality, that's really more easily dealt with tax and redistribution schemes. Protection of democracy, that's a matter for campaign finance, etc. Some of the other concerns here, I think, are best left just unaddressed. The loss of inefficient businesses, that is an unfortunate thing, but that's just the nature of economic progress. That's Schumpeterian creative destruction. Job losses occasioned by efficiencies, the same thing. Maybe we ought to have some sort of protections for the people who lose their jobs, etc. But we don't hold back economic progress in order to protect those folks. Another reason to not want to get rid of the consumer welfare standard, in addition to the fact that it really addresses a lot of the concerns of the neo-Bendicians, is that we've tried multi-gold antitrust before, and it hasn't really worked that well. So in the 50s and 60s, the courts would talk about the importance of low prices, protecting consumers from collusion and the high prices that come from that, etc. And then they'd say things like this. A competitor who's forced to reduce his price to an all-time low in a market of declining prices will in time feel the financial pitch and will be a less effective competitive force, therefore lowering your prices back. We cannot fail to recognize Congress's desire to promote competition through the protection of viable, small, locally owned businesses. Congress appreciated that occasional higher costs and prices might result from the maintenance of fragmented industries and markets. It resolved these competing considerations in favor of decentralization. These are from the U.S. Supreme Court, where it says, yeah, low prices are important, but these other things trump. Okay, so think about what that means. If the law is going to pursue consumer welfare and the protection of small business and democracy and all of these other things that we've discussed, income inequality, then the enforcer has a tremendous amount of discretion. The enforcer can say, we're going after this practice because it's bad for democracy. Yeah, it results in lower prices, enhanced consumer welfare, but it's bad for this reason. And the courts, are typically going to defer. So in this era, when we were seeing this sort of thing, Justice Potter Stewart wrote this. You can hardly see that, but he writes, the sole consistency that I can find is that in litigation under Section 7 of the Clayton Act, the government always wins. We went through a period of time when that's how antitrust worked. Robert Bork, at the beginning of his book, The Antitrust Paradox, starts by comparing then prevailing antitrust rules to the sheriff of an Old West town. And here's what he wrote. He did not sift the evidence, distinguish between suspects, and solve crimes, but merely walked the main street and every so often pistol whipped a few people. So I think if we abandon the consumer welfare standard, that's what we're going to go back to. And I think that would be a very bad thing. All right, so second screen. harm to consumers, consumer welfare is a necessary, but I would say insufficient condition for antitrust intervention. The second question that you want to ask is, has the defendant extended market power or just exercised it? So extension versus surplus extraction. We're seeing a lot of calls now to just go after charging high prices or pricing in a way that gets more of the surplus for the producer, even when the bad activity doesn't somehow enhance, extend, maintain the monopoly power of the defendant. I don't think that's a good thing. So here's some examples of this. Harry First, who teaches law at NYU, has written an article in the Antitrust Law Journal saying that excessive drug pricing can be an antitrust violation, just charging high prices for prescription drugs. Jason Furman, former chair of the Council of Economic Advisors in the Obama administration, wrote for the UK Digital Competition Expert Panel, we want to go after algorithmic personalized pricing. So we're concerned that these tech platforms are going to basically offer different prices to different people based on their likely willingness to pay. Right? That's a matter of price discrimination. And it does allow the seller to extract more of the surplus from the transaction for the seller. But it does not extend the seller's market power in any way. John Newman has written about this thing called digital blackmail, which I won't describe because I'm pretty much out of time here. But in any event, I think that these exercises in just surplus extraction should not be deemed antitrust violations for a couple of reasons. First of all, just an administrative reason. How do you administer that? How do you say how much extraction is allowed? You know, if we're going to say that excessive drug pricing is an antitrust violation, well, how much profit can you make before you cross the line to illegality? Another reason not to go down this route is that surplus extraction, profits for the producer, is a key to dynamic efficiencies. If you think not just statically right now, but if you think in the long run as markets develop, is this going to be good or bad for consumers to limit the profits that producers can make? First of all, surplus extraction is a spur to innovation. You try hard to come up with the new thing so that you can make a lot of money off of it. Let's see, was it Learned Hand in the Alcoa decision talked about this issue, and he wrote, "Finis opus coronat." I love that. The end of the work is the crown. Like if you go and you build a better mousetrap, what you get in exchange for doing that is a lot of surplus. In addition, super competitive profits often fund research and development. So right before I came up here, I Googled to see who the top spenders on R&D were, research and development, in 2018. Number 1, Amazon. 2, Alphabet, Google. 5, Intel. 6, Microsoft. 7, Apple. Facebook was in the top 15. So 6 of the top 15 were these tech companies. 5 of the top 15 were pharmaceutical producers. Right? They're spending a lot of money. It takes a lot of money to develop these new things. You get that by extracting surplus. If you're extracting surplus but not at the same time extending your monopoly power, that, in my view, should not be an antitrust violation. We need that in order to encourage dynamic efficiencies. News screen number 3. Is there another body of law that's capable of addressing the anti-competitive harm at issue? All right, I'm going to kind of skip through this because I'm really out of time. But basically, what I was going to talk about here with you, and I will in the Q&A if you want to, is some recent antitrust decisions involving standard essential patents. There's been some concern that people who have patents that get incorporated into technology standards will then turn around and engage in conduct after their patent's been adopted in the standard that involves some sort of a holdup, and they can extract more surplus from folks, etc. So if there was one challenge when the SEP holder sought an injunction, they tried to negotiate royalty rates. There's another when, this is the Qualcomm case that's been mentioned, standard essential patent holder refused to license to rivals. Now, there is some anti-competitive potential in all of these behaviors, but every single one of them can be policed with another body of law. If you seek an injunction, patent law says you don't get the injunction unless you prove that it's in the public interest. So there's something built into the law on whether the injunction is granted that takes account of that holdup potential. Renegotiating royalty rates, we've got swaths of contract law that are designed to deal with the problem of renegotiating and hold-up situations. The old Alaska Packers case, the doctrine of economic duress, etc. Refusing to license to rivals. Qualcomm was bound by this, what we call a FRAND commitment, an obligation to license on fair, reasonable, and non-discriminatory terms. That was totally capable of handling the issue of patent holdup. Antitrust didn't need to step in here. Now you might say, well, why don't just have a belts and suspenders approach? Let antitrust supplement patents and patent law, contract law, etc. Well, the reason for that is that antitrust has a unique enforcement provision. You are entitled to treble damages under the antitrust laws. All right, so if the remedy is a treble damage remedy, we're going to tend to get over-deterrence of good seeking of injunction and good renegotiation of royalty rates, etc., because you're worried not just about paying for the damages that you create, but also the multiplier. These other bodies of law that address the anti-competitive concerns don't have that multiplier built in and therefore aren't likely to create over-deterrence. So I would limit antitrust to situations where there's not another body of law that addresses the anti-competitive concern at issue. My last one here is reengineering, continued monitoring, or rate setting required to remedy the anti-competitive concern. And I'm kind of glad we're out of time because there's a lot to talk about with this, so maybe we can do this in the Q&A. Lots of ambitious plans. Break up Facebook and Google. How do we do that? They share production teams. I mean, they have software developers at Google that work for Google and YouTube and Google Maps, and they're all of the divisions. If we break them up into schemes or into pieces, where do those development teams go? How do we break them up? Google uses technologies across the whole entire ecosystem. So it's got this part called it's got the Google file system. It stores data sets for Google Search, YouTube, Google Maps, Google Ads. If we split Google into these parts, what do we do with that? Same thing for Facebook. I won't go into the details on that. But we're talking about re-engineering the companies. Jason Furman has suggested that we should treat data as an essential facility. So these big companies that amass a whole lot of data would have to sell the data to other competitors that want it. Okay, at what price? Who sets that price? Right? Is a court going to set the price? How do they know what the price should be? Eric Posner, Fiona Scott, Morton, Glenn Weil have proposed to restructure the entire mutual fund industry. I won't go into the details on that. But here's the point. All of these ambitious plans ignore the lessons of this guy. I'm sorry, I can't give a talk without bringing him up. F.A. Hayek. Hayek made this point, central economic planning requires a tremendous amount of information that is not given to anyone in its entirety. It's produced through market exchanges, it shows up in the form of prices, but when you don't have those prices, you don't really know how to allocate resources. You don't know how to structure things. So that's one economist that I think we should pay attention to. The other set of economists I think we should pay attention to are the public choice economists. Those who have said, when people step into the public sphere, they don't leave behind their fundamental nature as rational self-interest maximizers. There's lots of ways that you can manipulate public power for private ends. So some of these schemes would entrust to, the FTC or some other public body, the task of revamping the mutual fund industry, or whatever the issue is. When you do that, you invite all sorts of manipulation of public power for private ends. And I personally would not like to see that brought into antitrust. So those would be my 4 additional screens for today. Okay, thank you. I made a filibuster, I think.
No, you're good. You're good. Folks, questions?
So you spoke about it earlier at the very beginning, talking about the employment context and anti-poaching. Do you think that the law addresses that issue sufficiently? And if not, how do we do that?
So I'm not sure that there's been sufficient enforcement,
Okay.
but I think that the law certainly reaches it. So, anti-poaching agreements are contracts in restraint of trade. They're covered by Section 1 of the Sherman Act for sure. That it's well understood that monopsony power, buyer market power is analogous to seller market power. And so the law certainly reaches these sorts of things. We are seeing a lot more activity on no-poach agreements, et cetera. There was a big no-poach agreement among the tech companies that they got in trouble over. Now we're going after sort of franchisors, et cetera, for where covenants not to compete don't seem to really make much economic sense. And there's an argument those are unreasonable restraints of trade that I think makes a good bit of sense. So to me, while there may have been under enforcement, the law certainly reaches unreasonable restraints of trade in buyer markets, and we shouldn't change the law in light of those concerns.
Wasn't there just, was it North Carolina and Duke hospitals got in trouble for not poaching each other's doctors?
Yes, yeah.
I mean, that all seems to me like a sort of, talking about consumer welfare, basically that means really sort of the disadvantaged party to the transaction.
Right.
It's not, I mean, if people are saying consumer welfare means you can't take into account monopsonies, they're just being overly simplistic in understanding what that phrase means,
Right, yeah. That's certainly, Herbert Hovenkamp and Carl Shapiro have both made this point, that the consumer, we're using the term consumer to mean the person on the other side of the transaction. So if you're using market power in a way that injures the person on the other side of the transaction, antitrust reaches that. And that's how it's been understood. I can see why people want to latch on the term consumer welfare and say it doesn't reach all these things, because the term's really not a great term, but it certainly is meant to police harms to whoever is on the other side of the market.
Okay, anyone? Well, it's now exactly
Timing.
perfect.